A confessional statement given by an accused person before a police officer is inadmissible in evidence. Let's learn more about the facts of the case. Welcome to Legal Hazel, where laws made simpler. Let's assume the informant as Mr. A and his wife as Miss X. On the fateful night, Mr. A and Miss X were on a dinner engagement. While on their way back to home, Mr. A received a phone call from a neighbor of his father-in-law, stating that the gates are open and the light of his father-in-law's house are still turned on. Mr. A, along with Miss X, apprehending that his father-in-law might have collapsed due to his history of heart disease, rushed to his home immediately. As the couple reached his home at around 11:30 p.m., Mr. A found the dead body of his father-in-law lying in a pool of blood. Mr. A lodged a fire immediately and post-mortem report revealed that the cause of death was due to ante-mortem injuries in the front neck. Subsequently, the investigation commenced and 5 accused persons were arrested in connection to another case of dacoity and murder. All the 5 persons were taken into police custody and they confessed that they had killed the father-in-law of Mr. A and got away with the cash and jewelry. The confessional statements of the accused person were video recorded by the police officials. Accordingly, charge sheet was filed against all the 5 accused persons and the case was committed to the trial court. The prosecution examined as many as 17 witnesses, apart from forensic evidence, seizure memo of weapon of crime, discovery of gold ornaments, and built up the case against all the 5 accused persons based on circumstantial evidence. Eventually, all the 5 accused persons were convicted by the trial court under section 302 and 34 of the Indian Penal Code and were sentenced for life imprisonment. The accused person approached the Karnataka High Court challenging the trial court's order of conviction and sentence. Karnataka High Court refused to interfere and upheld the order of conviction and sentence passed by the trial court. Eventually, 4 out of 5 accused persons approached the Supreme Court of India. The Supreme Court observed that number 1, there is no direct evidence. Number 2, there is no forensic or scientific evidence which links any accused person to the crime. Number 3, discovery of the weapon of crime and discovery of stolen gold material is also severely flawed. Number 4, as the entire case is based on circumstantial evidence, therefore the entire chain of evidence must be complete and it must point towards the guilt of the accused person and no other conclusion. However, it is missing in the present case. Number 5, the entire case of the prosecution is built upon the confessional statements made by the accused person, which was also video recorded by the police. Those evidences are inadmissible as evidence under Article 20, Clause 3 of the Constitution of India and Section 25 of the Evidence Act. Hence, the Supreme Court set aside the order of the trial court and High Court and released the accused person from jail. Like and subscribe to Legal Hazel for more such new animated videos.